Imagine an abused defendant. After heavy drinking and a vicious taunt about an affair, they pick up a kitchen knife and strike a fatal blow. As a law student, your task is to classify this exact scenario. Is it murder or is it voluntary manslaughter? The physical act of killing and the specific intent to kill are absolutely identical for both of these crimes. The distinction rests entirely on your ability to successfully apply strict statutory partial defenses. The Coordinators and Justice Act 2009 operates as an unforgiving Boolean logic gate. You either meet every single statutory requirement or the defense fails. Mastering these rigid gateways is the only difference between securing judicial discretion for a client and a mandatory life sentence behind bars. English homicide law blends centuries of common law with modern statutory frameworks. This flowchart illustrates the legal decision matrix. Notice the top nodes asking if the defendant caused death and intended to kill. You must establish murder intent before considering partial defenses. Failing this roots the defendant definitively back to a murder conviction. To dismantle problem questions without falling into logical traps, you must adopt this exact chronological framework. Before looking for an exit, the prosecution must first prove the baseline elements of murder beyond a reasonable doubt. This diagram breaks down the specific dual-branch decision tree for murder. We start on the left with the Actus Reus, unlawfully causing the death of a human being. Identifying a human being is usually straightforward, but the high-profile case of Rea tested this limit, questioning whether a weaker conjoined twin, dependent on her sister for survival, constituted a separate person. The Court of Appeal ruled that physiological interdependence does not negate separate legal personhood, provided clinical judgment deems the child alive and separate. Once the Actus Reus is satisfied, we move to the right branch, the Mens Rea, traditionally called malice aforethought. In modern terms, this means the intention to kill or the intention to cause grievous bodily harm. Do not confuse a defendant's motive with their legal intent. In the case of R.V. Inglis, a mother injected her severely disabled son with a lethal dose of heroin to end his suffering. Her motive was pure benevolence, but because she intended to cause death, she perfectly satisfied the mens rea for murder. Once this baseline of a deliberate killing is met, the burden shifts. The defendant is guilty of murder unless they escape through a statutory gateway. The first gateway is diminished responsibility, under Section 52 of the Coroners and Justice Act 2009. Here, the legal burden of proof uniquely shifts to the defense on the balance of probabilities. This diagram maps the 4 strict statutory elements required to prove diminished responsibility. All 4 must be present. The first 2 requirements demand that the defendant was suffering from an abnormality of mental functioning, and that this abnormality arose from a recognized medical condition. This text from the World Health Organization's ICD-10 classificatory list shows the standard required by the courts. Conditions like alcohol dependent syndrome are formally recognized, whereas a temporary bad mood is not. The third requirement: the condition must substantially impair the defendant's ability to understand their conduct, form a rational judgment, or exercise self-control. Finally, there must be a causal link. The abnormality must provide an explanation for the act of killing. The statute is ruthless. Failing to satisfy even one of these 4 nodes collapses the entire defense instantly. Examiners will inevitably test this framework by introducing a complication, a defendant experiencing an underlying mental abnormality while also being voluntarily intoxicated. The House of Lords addressed this exact scenario in R.V. Deichmann, questioning whether the voluntary consumption of alcohol immediately invalidates the diminished responsibility defense. The ruling demands a specific conceptual task from the jury. They must mentally separate the alcohol from the illness. The defense survives if the jury concludes that the underlying abnormality would have substantially impaired the defendant's mental responsibility even if they were completely sober. Contrast this with the Court of Appeals ruling in R.V. Dowds. Acute voluntary intoxication without any underlying alcoholism or dependency is never a recognized medical condition. The law acts as a shield for genuine mental impairment. It strictly denies a free pass to voluntary drunkenness. The second gateway is loss of control, governed by Sections 54 and 55 of the Act. Unlike diminished responsibility, loss of control carries a unique evidentiary burden. If the defense produces sufficient evidence to raise the issue, the prosecution assumes the burden of actively disproving it beyond a reasonable doubt. Section 54 establishes a strict three-stage statutory test. Element 1 is the subjective requirement that the defendant's acts resulted from a genuine loss of self-control. In 2001, Tony Martin shot a fleeing burglar. His defense failed the subjective test. Shooting a retreating victim demonstrated calculation, not a genuine loss of control. Furthermore, Section 54(4) explicitly excludes any action driven by a considered desire for revenge. The law accommodates different timelines. Kiranjit Aliwalia suffered years of abuse before killing her husband, demonstrating a valid, slow-burn loss of control. Element 1 requires a genuine psychological snap. The exact timeline does not matter, provided it avoids the trap of premeditated vengeance. If the subjective loss of control is established, we face Element 2, the qualifying trigger under Section 55. This acts as the strict objective gatekeeper. There are two legally valid triggers. The fear trigger applies to a fear of serious violence. The anger trigger applies to things said or done that constitute extremely grave circumstances and cause a justifiable sense of being seriously wronged. This brings us to a highly controversial statutory exclusion. Section 55(6)(c) directs that a thing said or done which constituted sexual infidelity must be disregarded. The Court of Appeal confronted this in R.V. Clinton, addressing whether this statute meant infidelity could absolutely never be mentioned in a loss of control defense. The Clinton ruling established a crucial nuance. Sexual infidelity cannot be the sole trigger, but it is not subject to a blanket exclusion in court. Infidelity can be legally submitted as essential context to evaluate the gravity of other accompanying insults or threats, giving the jury a complete picture of the trigger. Finally, Element 3 introduces an objective standard test. The jury must ask if a person of the defendant's sex and age, with a normal degree of tolerance, might have reacted in the same or similar way. Even if the defendant subjectively felt wronged, the judge will dismiss the defense if a jury wouldn't find that sense of wrong objectively justifiable. Let's return to our initial exam problem, the abused defendant who stabs their partner after heavy drinking and a taunt about an affair. We now have the complete statutory blueprint to resolve it. Step 1 is the baseline. The physical act of the fatal stabbing and the deliberate intent behind it definitively establish the Actus Reus and Mens Rea for murder. Next, we apply the Diminished Responsibility framework to the facts of heavy alcohol consumption and abuse. We must test for a recognized ICD-10 condition, such as battered person syndrome or alcohol dependence, versus mere voluntary intoxication, applying the Deichmann separation rule to see if the impairment stands on its own. Simultaneously, we apply the loss of control framework to the affair taunt. Using the Clinton ruling, the infidelity taunt provides essential context for an anger trigger alongside the abuse history, while checking the timeline to ensure the stabbing wasn't calculated revenge. Clinical precision in distinguishing between these statutory gateways is the defining trait of a top-tier law student. Rely on the rigid structure of the Coroners and Justice Act 2009. It is the only tool that turns a complex, chaotic problem question into a definitive, successful legal argument.